This is the issue, and I am the Ghetto Man. Today's issue, jurisdiction and separation of powers. Don't go away, we'll be right back. Our constitutional republic is divided into three co-equal branches of government: the legislative, executive, and the judicial branch. Each branch of government has a limited amount of power and jurisdiction, and all three branches of government must act within the limited authority as mandated by the U.S. Constitution. The legislative branch creates the law. The judicial branch rules on the law, and the executive branch executes the law or enforces the law. The power of all three branches of government are bound by the U.S. Constitution, and any powers not delegated to any of the three branches of government by the U.S. Constitution are reserved to the states or to the people. In a United States Supreme Court case called Massachusetts v. Mellon, the United States Supreme Court said this about jurisdiction and the separation of powers. Quote, "The functions of government under our system are apportioned," meaning that they're divided into three separate branches. "To the legislative department has been committed the duty of making laws, to the executive the duty of executing them, and to the judiciary the duty of interpreting and applying them in cases properly brought before the courts. The general rule is that neither department, either branch of government, may invade the province of the other, and neither may control, direct, or restrain the action of the other. We have no power per se to review and annul acts of Congress on the grounds that they are unconstitutional. That question may be considered only when the justification for some direct injury suffered or threatened. The party who invokes the power must be able to show not only that the statute is invalid, but that he has sustained or is immediately in danger of sustaining some direct injury as a result of its enforcement, and not merely that he suffers in some indefinite way in common with people generally." And that case is called Massachusetts v. Mellon, and it can be found in Book 262, U.S., on page 447. It's a 1923 case. When the president exercises his constitutional authority by closing the borders, as an example, or not allowing people to enter our country illegally, or not allowing people to enter our country from countries known for terrorism, no court can issue an order stopping him from exercising these constitutional duties. The judicial branch of government does not have the authority to override the governmental acts of the other co-equal branches of government. No court has the constitutional authority to direct, restrain, control, or otherwise invade the separate and distinct powers of the other two branches of government. The court has no power in itself to review and or nullify acts of Congress or the acts of the executive branch on the grounds that they are unconstitutional. The courts have no jurisdictional authority to interfere and stop a government action unless there is an issue in controversy, where the government's actions are in direct violation of a U.S. citizen's right to life, liberty, and property, and a lawsuit. This is very important. And a lawsuit has been filed by that citizen that has been damaged by the government's actions. It is through the filing of the lawsuit that the court gets subject matter jurisdiction and assumes power over a claim, which it is authorized to hear under the laws of its jurisdiction. If the court finds that the government's actions did, in fact, violate a citizen's constitutionally protected rights, then and only then can the court make a ruling and an order declaring the government's action or law unconstitutional. Foreign nationals and other non-citizens entering the U.S. illegally have no legal standing under U.S. law whatsoever. They are criminals and they must be treated as such. The courts cannot interfere with the president's constitutional authority to protect our nation's border from foreign nationals entering and invading our country illegally, period. If a U.S. court does invade the separate and distinct powers of the executive branch of government and orders the president to leave the borders wide open, as an example, and allow all foreign nationals to enter the U.S. in violation of our immigration laws, does the president have to obey that order? Well, the answer is no. The president is under no duty to obey and or enforce that order. Andrew Jackson, the 7th President of the United States between 1829 and 1837, he knew exactly how to handle this situation. Andrew Jackson understood the law, he understood jurisdiction, and he understood the doctrine of separation of powers. So when the U.S. Supreme Court issued Jackson an unconstitutional order, Jackson knew that he wasn't bound to obey it, so he didn't. He refused to execute the order and quickly remind the court that, quote, John Marshall has made his decision, now let him enforce it. I am the Ghetto Man. Thank you for watching. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. Please subscribe to my BitChute channel and please share.